Welcome to the Essential Tax Podcast with your host, Mishkin Santa. In each episode, we'll take the complex world of tax, all the jargon, acronyms, and stuff that make your eyes glaze over, and explain it in an impactful way to understand the complex and unknown areas. You can find this show on all the major platforms, including YouTube, LinkedIn, Apple Podcasts, Spotify, and on our website, thewolfgroup.com. Now, here's the host of Essential Tax Podcast, Mishkin Santa.
Hi, everybody. Welcome to the podcast. Today's topic on the podcast, I'm trying to really kill two birds with one stone. I want to talk about a Supreme Court case called, well, actually, it's two cases that they kind of put into one, Loper Bright and Relentless Inc., but we now call it Loper Bright. I want to talk about Loper Bright because I feel like everyone talked about the Moore case when it came out. And in fact, we did one of our first podcasts on the Moore case with with my guests, one of his colleagues. But I want to talk about that. And then I want to talk about a topic that I get asked regular questions about, but it's called private letter rulings. There's not a lot out there on the web, on the interwebs, on private letter rulings, like how they actually work and when to use them and what you can use them for and costs and all that. But I want to talk about both of those topics today with our guest. And so just kind of giving some background there before we get started. But let's get into it. Welcome to the podcast, Joshua Smeltzer. How are you today?
I'm doing great.
Awesome. And do me a favor, give our audience some background on, where how you came up through the ranks, where you started from, what licenses you hold, where you practice, your law firm, things like that.
Sure. So I started my career at the Department of Justice. They have an honors program. They'll take people right out of law school. And I applied for that, and I was lucky I got in. So I was able to start there at the Department of Justice in their tax division, litigating tax cases throughout the country. And so that's kind of where I did. And I was there for a long time. I was there for 14 years.
Wow.
And so I did the smaller cases, small businesses, some individual stuff at the beginning. And when I left the Department of Justice, the case I was working on was a $1.3 billion tax refund involving oil and gas. So I kind of saw the very small all the way through to the very beginning. But I left the government in 2018 for private practice. And I've enjoyed it a lot. I do a litany of things, but because of that Department of Justice background, I'm primarily a civil and criminal litigator for tax issues and things like that. We do some planning and some other things along those lines. I'm board certified in tax by the Texas Board of Specialization as well. And I run our tax controversy and tax litigation group at the firm of Gray Reed. Gray Reed is about 150 attorneys strong. We have offices in Dallas and Houston in Texas, but I represent clients throughout the country because it's federal tax. So I have them on both coasts and everywhere in between.
Yeah, and I think you were telling me you were considering perhaps waving into DC, and I think you've got some background in Maryland as well too. Is that right?
Yeah, so I am licensed in Maryland, and I am thinking of waving in DC. We've just had several clients come up there, and for most of the stuff that we do, advisory or working at the IRS level, it's not necessary to be licensed. But if you do have to go to court, then I would have to be licensed in that jurisdiction. And so it's becoming more of a need just as more stuff is coming up and we're having more clients in the DC, Maryland, Virginia area. Gotcha.
Yeah. And Gray Reed, I love that firm. I've been using that firm to help with legal issues with my clients for many, many years. So not sure if the audience knows, but my stance is pretty simple. The Wolf Group is a certified public accounting firm. We shall stay within our sandbox of accounting work and not meander outside to legal work. So anytime we need, or the need calls to have an attorney come in, and a lot of people think, oh, attorney, I only need them for a criminal matter. But attorneys, in my opinion, good tax attorneys like Josh here, and the folks at Gray Reed, they are super handy on a wide variety of issues that are not just criminal related. They could be anywhere from, hey, let's help, determine the impact of, selling this business, or doing a check the box election, or, how do we approach this issue that maybe has some gray area to it, whether it's domestic or international, which we'll talk about with the private letter rulings later today. But I think finding, a good outlet, a good law firm to kind of serve as a helpful backstop to some of these things is worth its weight in gold. It's funny enough, also, what you said about starting out with the DOJ and doing some of those smaller cases and then working your way up. That made me remember that when I was with the IRS, my first case that I argued, I was with SBSC. I think it was like unpaid taxes on like a paper route.
Yeah.
It's funny how they start you off on kind of those lower level cases, and then you're like, oh man, is this really what I'm going to be doing? And then as time moves on, you kind of work your way up. But I guess that's just about
and I mean, I will give a plug. I give a plug to all young attorneys that at least a small stint in the government is just it's also worth its weight in gold, just because I mean, it's only there where a small case like that someone would allow you to kind of do the full litany of litigating and building it up and figure out what the issues are, because it isn't cost effective in private industry. And so I enjoyed my time at DOJ. I got to go to trial 14 times and all kinds of other things that just isn't as possible in private industry because of kind of the costs and other things involved that way. So it's a great way to get experience, and I think it's a good thing to do as well.
So take note, all young attorneys out there. Definitely solid advice there. Okay, let's get into the first big topic here, which was the Loper Bright case. That's a Supreme Court case. I believe the decision on that one came out around June 28th of this year. Obviously, I believe that was heard back in 2023. But Josh, can you walk us through kind of why this case came to being? I mean, when I looked at this case, it was like, okay, well, we're arguing over whether fishing boat owners should pay for federal regulators to come onto their fishing boats. What does this have to do with tax? Why is this having such a big impact? Can you just walk us through Chevron, the Chevron Doctrine, Skidmore deference, kind of just talk to me like I'm a 3-year-old. Why is this important? Why is Mish bringing this up today on the podcast?
Sure. So yeah, the actual issue of fishermen and having to pay for these having to pay for monitoring because it's an unfounded mandate. What it really gets to the heart of is, as our administrative state has grown, it's become more and more necessary for these agencies to be making decisions on what the law means. So we have a lot of regulations, we have a lot of guidance, we have a lot of that going on. And especially in the tax field, right, as complicated as it is, we rely on a lot of regulations, guidance, informal guidance, FAQs, all these things for the interpretation of what's going on. Now that's a good thing. A lot of times we're welcoming of that guidance so that we can make the right decisions, make the right moves, make sure that we're coloring within the lines. The problem is when there is overreach, right? Okay. If there's something if it's on the line, because of Chevron, the tie always went to the IRS. It just always did. So Chevron Doctrine came out, I think, oh my gosh, it's been with us for, I think, almost 20 years, if not a little bit more than that. But essentially, what it said was that an agency was given deference for their interpretation of the law. And as such, that's what created this kind of tie goes to the IRS mentality. And what I think it led to was, and it's been confirmed by surveys, anonymous surveys, what it led to was a lot of the regulators, they were taking more and more aggressive positions with their regulations, knowing that all they had to do was get to 50-50. And if the court weighed it, then they always won. And so it took kind of this case where there really was this unfunded mandate, and they were passing on all the costs for monitoring to the actual company in order to do it. And I think that there's been lots of times where the court has wanted to reconsider Chevron only because it's been just so expansively applied. And so that's what Loper Bright did. And what it did was it essentially overturned the Chevron Doctrine. And what it put that decision on how you interpret the law back with the courts, which I think is the right decision. Right? The courts were the ones who were supposed to be interpreting the law. It's not the government agency. Now, in some cases, will the court still give deference to the IRS's position? Maybe. But at least it's the court's call in order to do that. And is that
what we call Skidmore deference? Is that what we're referring to when you're saying that?
So Skidmore deference is a little bit different, only in that that requires the agency to actually come up with a clear reason, and it has to be a substantial reason. They have to justify it. Chevron really was just it's ambiguous. Nobody knows what it means. The agency wins. Right.
So silent or ambiguous on an issue, tie goes to the IRS always, or the agency.
It's essentially right. Like, even if you had a really good argument as a taxpayer under Chevron, it's like, listen, we don't really have anything in the law. It's ambiguous, or it doesn't say anything. And so the IRS has told us it means this, and they're entitled to deference. So even though you're making a good argument that it doesn't, too bad. At least in Skidmore, they have to make the argument. And I think that's okay to keep that Skidmore deference, because you still have the courts essentially weighing the arguments. And that's, I think, all that taxpayers and practitioners really wanted, was they just wanted to be able to make an argument in a fair playing field where their arguments were given just as much weight as the government's arguments, so that the court can make the right decision and not lose out to deference. I mean, deference gives the court an easy way of not having to consider some hard issues. That way they can say, could go one way, could go the other way, but I have this deference proceeding that says I have to give deference to the IRS. So all things being equal, we're gonna go that way.
And so does Loper Bright, then this change, does that, I have a couple follow-up questions on that. Does that then go back to any decision prior to Loper Bright? And are we concerned that there may be a whole host of appeals there? Does it apply to any regulation that's already out? Does it apply to only regulations that come out in the future? Like, help me understand the map of the playing field now that we have Loper Bright.
So it's actually being used quite broadly. You're seeing Loper Bright pretty much thrown in any time that an agency has been ambiguous. Now, I think what a lot of practitioners are looking at right now is, some challenges you may be statutorily barred from.
Okay.
Right. Tax years close at some point, and neither the IRS nor the taxpayer can do anything about it once that tax year is closed. So you've got that. And so in tax disputes, I think that's the biggest limiting factor. If your tax year is closed and you got a Chevron decision on that, there's nothing you can do about it because the statute is gone for challenging anything that way. But for all the cases in audit that have a regulation that's either silent or ambiguous, it's being raised. And for a lot of regulations that have come out that were proposed regulations prior to this decision, I think there's going to be challenges to the application of those too, because decisions were made during the notice and comment period under the theory that, they were entitled to deference for certain matters. I mean, we've been having this fight for several years now. The APA, almost every tax lawyer has had to become an Administrative Procedures Act specialist.
And that's from the 1940s, right? That's from a way long time ago.
Yeah. That's what essentially, right? Congress just wasn't able to handle the legislation, writing out the legislation for everything because of how big the administrative state got. And so, it was created there as a convenience in order for the agencies to take some of the burden off of Congress for flushing out the specifics of these laws. And of course, when the problems arose where there were things that were ambiguous or they weren't mentioned or anything, they needed to have some way to deal with it. And that's how Chevron came about. But there's also everything else. The notice and comment process is where we've started with a lot of these. The conservation easements and the captive cases all challenged the fact that they were put on as listed transactions without any notice and comment period or anything else. And they were successful in that all the way up to the Supreme Court before it was said that they needed to, go through the notice and comment process. And now the IRS, you saw with the syndicated conservation easement, they went through the notice of comment process. They probably normally wouldn't have, except that decision was entered. So there's a lot.
The QROPs too, right? They at least offered the comments. No one made. I think there was like 5 comments, and they decided to cancel the hearing. But they at least offered to do it, right?
Yeah, and you're seeing the government as well, right? And it's fair. They they're underfunded. They're usually understaffed, and so for them, they were trying to do some items without having to go through the formal process because it takes a lot of time, it takes a lot of effort, and it takes a lot of cost. We've seen this happen before as well. I know the Wolf Group does a lot of the voluntary disclosure stuff for foreign bank accounts and things like that. When we had the offshore voluntary disclosure program, if you remember, the government couldn't get guidance out as quickly as they could get FAQs out.
Right.
So most practitioners were using FAQs as their guidance sometimes because it was the only information you had. Well, those had never gone through any sort of formal process, and the FAQ itself has no binding effect, and the IRS can remove it at any time. I remember actually printing off one of the FAQs, and when I went back to the website, it was gone.
Yeah.
Right? The only evidence that it existed was the printout. Mm-hmm. And so it was a matter of convenience that is going on. And the government, they don't necessarily always want to engage in this huge cost that is sometimes involved. And so I think that's what you're seeing is Loper Bright is saying that you have to actually go through the required steps. And with the APA challenges, you've seen that too, that they're saying, hey, you actually have to follow the APA. And that's all that this is. And Loper Bright, I think, was a continuation of the Administrative Procedures Act, and these formalities that we have built into our system, they have to be followed, right? And you can't give the court's job to the IRS just because it's easier. We still have to follow the law, and the courts are in charge of deciding what a statute means or doesn't mean, if it's ambiguous or silent. And so I think that's why it's important. For tax especially, one of the risks that I think might occur is that we may see that the IRS doesn't do as much guidance anymore. If it's going to be a lot of cost, a lot of hassle, we might not get as much guidance from them. I don't think that that's very welcome for us either. And hopefully after a few years, we'll be able to strike a nice balance between them still offering the guidance that practitioners need, but not overreaching to the point where they're, supplanting the court's job.
Right. And so we juxtapose, for example, and I know that you do a lot of this practice, but the digital asset tax regulations, right? With Congress can't put out laws fast enough on this area. And, the IRS certainly, I think, could, move as fast as I think they should, but they can put out regulations or propose regulations a lot faster than Congress can put out the laws. I think we probably want them to do that, but then you weigh that against, and I know that you wrote some comments on the proposed foreign trust regulations, which in my opinion were very IRS friendly. They didn't give a lot of relief to a lot of things. And so you're kind of like weighing like, okay, well, maybe this, but we want that. So I think you're right. There's a weighing there. And it's interesting that the observation is that this is kind of forcing the IRS to kind of do it by the book, one. And then number two, when doing it by the book, really trying to encourage the public to give more comments. And I think my opinion is if I'm the IRS, well, if I'm putting out those regulations, I want there to, that reasonableness standard, right? I want to be able to say like, look, we put it out there. We let it sit out there for a long time. We took X amount of public comments. We did this hearing, we put it to the test. And this is how we came out with what we came out with. So it's, we've got that reasonableness there. I think we'll see a lot more of that happen as time moves on for certain.
Yeah. And you mentioned comments. I think that's going to be very important going forward for organizations like we did comments through the State Bar of Texas, but the AICPA does a bunch of comments as well. And also even our firm sometimes will do it under our own banner. If we have a lot of clients for whom it affects, we will sometimes make comments as well. And that's important. And especially with Loper Bright, the IRS has to look at those a little closer now because they don't have the benefit of deference. So if somebody raises something that, hey, we think this is ambiguous, and if challenged, it should be interpreted this way, they can't just lean on the fact that, we have deference, so we're going to go with our interpretation. I think they are going to treat comments differently. Sometimes I felt that my comments were a little perfunctory because they had just made up their mind.
Right.
Other times I feel like they consider them a little better, but I think that it's going to force them to actually consider them a little better each time. And
the Administrative Procedures Act, those challenges have been going on. I mean, that was the flavor I saw a lot in 2023. Yeah. We had the arrestee case where they talked about that with the U.S. exit tax, which in my opinion has a massive hole in it. That just has that one notice. Yep. It's missing a form. The 708 form doesn't even exist, and that was back in 2009. So I think the APA stuff has been going on for a while and will continue to be kind of a thorn in their side. Especially, it's kind of like the sins of the past, right, or the ghosts of the past. They're now kind of all percolating up here on areas that they just never had good coverage on to begin with.
Yep. And I mean, right, it was out of convenience, and everybody knows why, and they hoped they could get away with it. And those were the arguments they made against it in each of the cases where it was challenged, was it would just be too administratively difficult for us to run everything like this through notice and comment. But I mean, the law's the law, and the law has to change. If it's required for notice and comment, you have to do it. And so, yeah, I think that's going to continue to be a thing because it's gotten decent relief for a lot of taxpayers who, without any chance to comment, were subject to a bunch of these rules, and that's not fair either.
So let me ask you this then. If I'm someone under audit or examination, I got my attorney telling me hazards of litigation, Loper Bright, you're throwing out big words there. How are you using this as a sword and shield in your practice? Are there any specific areas that you think it's something people should really consider? Or, how are you deploying Loper Bright moving forward?
So it is being used a lot, I think, in the digital asset space because there isn't a lot of guidance there and a lot of regulations. So we have been using it in that space as well. The other thing is anytime that you have a regulation for which that's what's being used as the government's defense, instead of the law, right? Because sometimes they'll cite the statute and they'll say this is what the statute means and that kind of stuff. But a lot of times they'll cite the regulation because the statute really doesn't say what it needs to say in there. And that's where I'm saying, that's where I'm seeing, and that's where I'm advising clients that, hey, listen, I think we may have an argument here on that. The other thing is that a lot of those may never even see the courtroom, because I think for IRS appeals, their only job is to consider litigation hazards, and they right now are trying to figure out exactly how big of an issue this is. And so if you have something right now that does have a regulation that might be subject to Loper Bright, I really think that right now is probably where you have the most leverage for negotiations with the IRS appeals right now, because the thing that the IRS doesn't like is the unknown, right? And it's really unknown how far this is going to go and how many regulations might be re-examined, questioned, and other things like that. So if you have a case that maybe has some bad facts, isn't necessarily a great candidate for taking all the way to trial, and should be settled, then, that is something that you can probably use to convince the IRS that there's maybe more litigation hazards there than they think, because of that new law and because of the uncertainty that goes around. That's one thing that taxpayers always have as their leverage, is taxpayers only care about their case, but the government cares about the impact that case is going to have years. Because they have to deal with it going forward. And that, I think taxpayers have a lot more leverage with that right now, just because it's essentially called into question a whole slew of regulatory interpretations that people can do.
Right. Wasn't it the Jarrett case? Didn't they just refile under something similar? I mean, that's when the IRS wants to go away really badly, and it just kind of, it's like that penny that keeps popping back up for the digital asset.
And the Jarretts, they said that this was going to occur before, because so in standard refund litigation, right, you pay and then you sue to get your money back. And the government saw it, and unfortunately, it just wasn't a lot of money. And the cost of getting a bad decision certainly outweighed the cost of just giving them their money. And so that's what the Justice Department did. They just gave them their money, and the whole moots the entire suit. And they tried to go to the circuit court and say it doesn't moot it for exactly that reason. They said, we're going to have this exact same problem next year, and we're just going to have to file. And the Justice Department was successful in arguing that every year stands on its own, and they may have to file next year, but that's just how it is. And so, true to form, that's exactly what happened. And now they filed it. Now it'll be interesting to see, because that complaint was just filed there. It'll be interesting to see, because going back a little bit to the Loper Bright decision, I didn't see anything in the complaint that necessarily raised it. But if there was an angle for Loper Bright, that may be an angle which could keep the case alive. Even if the government were to pay it, it would still keep the case alive because of that challenge that has gone on. I don't know. And it'll be interesting as well to see what the government does in its answer, because it has 60 days to answer. And it'll be interesting to see if the government says, we don't want to just keep paying them every single year. See if they're ready to have the fight now. Someone needs to have that fight. I mean, the government kind of unilaterally decided how they were going to treat these staking awards, because there's literally nothing. There's still no law that they can point to. And so they decided to treat it the way that they wanted to treat it. And I mean, it would be interesting for a court to weigh in on both sides to decide, really which is the right interpretation. And without Loper Bright, without other things like that, it would be it. I'm curious. I'm definitely watching that case. I watched it the last time. I'll watch it again this time.
I will too. So two more questions on Loper Bright, and then we'll move on to PLR. So, in my area, and I mentioned this to Austin Carlson during his podcast, when the Moore case came out, when we're talking about doing IRS amnesty, you talked about Wolf Group doing a lot of voluntary disclosures, which we do. There's a special carve out for individuals that never filed their transition tax reporting, where the IRS says, if you have an inclusion, a transition tax inclusion, which is, I guess, what pays for most of the TCJA, but you got to go back to 2017 and you got to refile or file, if you're a streamlined foreign, file from 2017 all the way on up, right? Now, we get to 2024's tax return or 2025's tax return. We start to get to 7 or 8, amended returns, or we start getting back into OVDP, right? The big,
yes. Giant packets that you had to send.
Yeah. And at what point does that become unreasonable or untenable or, beyond, and again, that's not a regulation. That's just a guidance that they put out in a written, on a web page for people. At what point does someone challenge that? Or even more so, if they get a bad result through streamlined filing, at what point does it challenge that as well too? Or, what could Loper Bright be used for beyond, just the normal regulations or proposed regulations, in your opinion?
So I think Loper Bright could be, it could be an avenue there as well. The problem that I think always occurs with those is IRS does a lot of things for administrative efficiency. Some of it doesn't even relate to the statute. Like you said, it's just that, hey, we have to process all these things and this is what we need to go. Amnesty programs are a little bit harder only because they're usually not codified, right? What happens is the IRS decides to give a benefit. They have a ton of leeway in deciding how those benefits are actually going to be given, right? It's a gift and they treat it as a gift, which means they attach all the strings that they want on it before they give it to you as well. So I think it's a little bit harder to do that. That's Loper Bright is going to have to be very creatively used in a lot of instances, only because you have to find some way to get to an interpretation, and you have to get, so the further you get away from the statutory language, the further you get away from IRS interpretation of that statutory language or lack of it, the harder it's going to be to find a hook that would get you into the Loper Bright avenue. And right, if there's any sort of hook, again, right now you have the most leverage, and that's what I would raise it. As long as it's not laughable, you might as well raise it.
Throw it in there.
Use it as some leverage, even if it's only to negotiate out some sort of settlement, or because you got a bad streamlined filing decision or something along those lines.
Okay. Last question for Loper Bright here. So everyone's waiting to see the next president of the United States, but I'm ready to get past that. I want to see what happens with the TCJA sunset. Yeah. And as a refresher, the 1986 tax code, which is it's not really apples to apples, right? But just comparing the two timelines, that was bipartisan, negotiated and talked about, meaningful discussions over 13 months. We fast forward to TCJA. My understanding is that they waited until September. They put all the tax writing committees in a room for 30 days, had them write up a lot of different proposals. Then they chose one, talked about it, I think, for like a month or maybe a couple of weeks. And then they put it out there in November. And then, there's not very many hearings on it. And then passed, signed into law, 6 weeks, didn't take very long. And bada bing, bada boom, we've got TCJA.
Yeah.
Now we think about, okay, there's the sunset, we got to see who wins the president. We got to see what happens after that. But sometime in 2025, Congress and the president have to figure out how to deal with the TCJA sunset. Some people are even calling it tax Armageddon. What happens if everything just kind of reverts back to pre-2018? And so do you think, because of Loper Bright and some of the APA stuff that's floating around there, do you think that kind of forces Congress to be a little bit more open about their discussions, give a longer timeline to going through it, having more meaningful hearings, things like that, to avoid potential challenges down the line?
I do. And I mean, it is the other benefit that I think we get from Loper Bright is I feel like Congress really kind of treats a lot of tax legislation short shrift, right? They have, they sometimes they'll have tax people on their staff. Other times they'll just take something that comes from private industry about tax things that should be added to legislation. And it's not given a whole lot of consideration, and it's not flushed out very well in the statute. It's the reason that you end up having to have as many proposed regs and guidance and everything else is because they know what they want the result to be, and nobody deals with kind of how they get there. They leave that to the IRS to do. And I don't think they're going to be able to get away with that very, very much. The TCJA, I mean, it's just a lot was changed. And I feel like it's put the nation in this kind of unenviable situation where a lot of benefits were given, and now people have depended on those. And to yank those out from people, people are going to be hurt if you remove it. There's no way to get around it. And even if intellectually you believe it never should have been there in the first place, you're going to hurt a lot of people. You're going to hurt a lot of industries. You're going to force people to make massive changes. And our economy is still not necessarily its most stable. So I think there's going to have to be a lot of compromises on those things. I mean, we deal with sunsets all the time, right? Legislation comes, it has a sunset. And at the end of every year, everybody talks about the stuff that's going to disappear. And whether or not it will continue and what happens if it doesn't. It's just not at this scale. This scale is much bigger than we're used to dealing with on there. But I agree with you. I think that we're going to see more from Congress to the extent they have time. The problem is if they don't have the time, I think we're going to see the same result. It'll just be treated kind of quickly, and then the IRS will be left to clean up the mess. And under our current scenario, that's going to involve the courts now.
Right. And so we're right back to where we started from.
Yeah. So. Yeah.
Well, I'm always hopeful in that area. I know that the tax writing committees are doing road shows, and they're trying to get the American public to kind of give their 2 cents on what they want to see happen, or what they want to stay, or what they want to go. So it sounds like the committees, because that's what I always tell people, in the end, it's president, Congress, whatever, but the committees are the ones that put the pen to the paper. They're the ones that you really got to get to and talk to. And, it's interesting when you talk to people that have served on those committees and kind of get their kind of inside baseball on kind of what went down. I was listening in such awe at what happened with TCJA. So it's be certainly interesting to see what goes around this time.
Yeah.
Let's move on to private letter rulings, because I get this request a lot, and it gives me a smile when I have a lead or a client come to me and inquire about a private letter ruling, because it means they've actually looked into it, they've actually thought about it, they've read something about it. They really believe in a certain tax position or a certain outcome. And these things aren't cheap, they're not easy to do, and they require a lot of help. Talk to me about, like, I'm a 3-year-old. What is a private letter ruling? Why would I use one? How much does it cost? Who needs to do it? Give me some basics on what's going on there with the PLRs.
So the IRS has a program. The private letter ruling program is essentially what it allows you to do is get an advanced ruling on something so that you can feel assured that if you take a certain position, you're not going to have to litigate it or argue about it on audit or anything along those lines. And the IRS won't do it for everything. Every year, they issue guidance, and there's a whole list of things that they will not accept private letter ruling for. So the first thing you do whenever anybody wants a private letter ruling is you check and make sure it's not in one of those prohibited things that the IRS has said they're not going to provide letter rulings on. Now, recently, they expanded the list, and it was news maybe a year ago that they were going to take more reorganization type requests and other things like that to allow taxpayers to get more advanced rulings. And I think that's a certainty thing. If you are a company or even an individual for whom you have a tax position that you're not exactly sure if the IRS will agree with your position, but you feel it's well-founded, it gives you certainty to file the private letter ruling, because what it does is for that taxpayer and their facts, that decision will get an answer that yes, you can do it that way. And what's just good practice is to ask, once you have that answer, if it's the one that you want, you get a closing agreement, because that closing agreement will solidify it and it cannot be changed. Because the IRS is not bound by that PLR thing. It can change its mind. But if you have a closing agreement, it cannot. And so that's important to think about as well. When you get to the end there, if it's what you want and you're willing to live with that thing, you want to get a closing agreement. They may change it for subsequent years, but at least the year that you asked about, you'll be okay for. It is pricey. $38,000 is the usual cost. There are some mitigating ones that can make it a little bit less expensive, but $38,000 is the top of that cost, and
that's the fee, though, right? That's just the fee that you're paying the IRS. That's not even talking about your fee, my fee.
$38,000 is the application fee. That's just what you pay for the IRS to consider it.
Okay.
And so, yeah, it is pricey. There has to be a decent amount of money involved, I think, for these to make sense. Because yes, once you have it, what a PLR also is this weird hybrid of both explaining the position and the accounting behind the position, but also advocating for a specific position. So it's this hybrid of legal and accounting, and almost many of the ones that we've done have been in collaboration, right? With accounting firms as well, to where we're helping with the advocacy piece on that, just because you are still advocating for a specific position. The other thing that I think you need to consider with a PLR when you're looking at one is, if you want that answer, because you will have lost at that point, right? And you will have given the IRS your entire litigation planning up front, and then if they say no, now, if you still want that position, you have to challenge it in the courts, and you've told the IRS everything that you have to support your position.
Keep doing on the playbook.
And so that is a factor that you need to think about as well, because the alternative is to get a tax opinion, which is just a legal opinion that your position has a sufficient amount of basis in order to be claimed on the return. That'll protect you from penalties, and then you can challenge it in court. Right now, there are lots of things to consider on whether or not you want to do a PLR. But if you have a position that you feel is going to be, you really want to be strong in your PLR position before you take it. If you do think it's something that might come down to factual determinations that require litigation or something like that, my opinion is you're probably better off getting a tax opinion and litigating it in court if you have to, and just saving your litigation plan for when you have to do it there. Because if it's something that the IRS decides they want to go to the mat on, they'll take that litigation plan and they'll just spend all the time they need to knock down every single thing that you have, and you lose kind of the advantage that most taxpayers have in that the IRS doesn't know anything that you don't give them.
Right.
And so all the benefit of kind of the legal discussions that you have with your lawyer and your accountant, to the extent that can be privileged under the accountant privilege, all of that stuff is kept with the taxpayer, as long as they want it kept with the taxpayer. And you lose that advantage in a PLR, because in order for a PLR to be successful, it really has to lay out everything. You open the full kimono and show them everything that's there, and ask them to make a decision on it.
So my takeaway there is there's strategy, there's positions you have to push to satisfy the government, and there's a full disclosure of all the facts and circumstances, all the evidence, everything you've got. It all has to be put on the line and on the table. So it's not, I have some clients that come to me and say, well, I'll write my own PLR, and I just kind of cringe at it. I'm like, you're really short-circuiting a lot of the process there, and you're making a lot of assumptions, and there's a lot of things I don't think that you're thinking about there. And by the way, just like you said, maybe you don't want to do the PLR, maybe you want to take a different route there. So I just want to make sure that the folks listening today understand that PLRs can be a good thing, but at the same point in time, I think it's always important to trust but verify with people like Josh or other attorneys that they're actually the right path to go under.
Yeah, it's not the right answer for everything, right? There is no silver bullet in the tax code. There's no silver bullet to your tax issue. Usually, in every case I've had, there's always more than one option, right? You find out what is it what's the goal, what's the result that we're hoping for, and there's usually 3 or 4 options to get there. A PLR can be one of the ones on the table, but considering that in isolation, I think, it's limiting, and it may not be the right answer when you know the other ones. The other thing that I think is that's interesting. I've never heard of anyone, saying they'll do their own PLR. The government is so hard to deal with anyway, and that PLR process is not an easy one. And for somebody without any sort of background in taxes or the system, I can only imagine what an exercise in frustration that would probably be, just because the IRS does do a lot of back and forth with whoever submits the PLR. They have a lot of questions. And if you don't have good answers to that question, the easiest thing for them to do is take your $38,000 and deny it.
They know. Yeah.
So, yeah.
What's funny is where I've seen it most is not necessarily with the IRS. I don't know if you know this, but Maryland actually has, I think it was a year or so ago, they have now a private letter ruling process at the state level.
Oh, that's good.
Theirs is free. And so I remember I put that in one of my updates because I do a lot of international organization presentations to World Bank, IMF. And those people, that got bless their heart, but they think that they can do just about anything. And I've had several of them be like, well, I'm just going to take it to the Maryland private letter ruling. And I'm like, good luck with that.
Yeah. Oh man, well that's interesting, right? Yeah. Here in Texas, we don't have state income tax, and so we don't do a whole lot of that. But our department we have plenty of other taxes. The comptroller has plenty of other disputes. But that's nice to have it. That's nice that they don't charge either.
Yeah.
Right?
Maryland's ambiguous though, because they have add backs. So for example, certain things that are exempt under federal, you may have to add back in for Maryland, but it doesn't really do a good job telling you, especially with the foreign income. It's like, is it really an add back? Is it not an add back? Like there's like a very open, broad interpretation there. And so I get what the folks are saying, but at the same time, I'm like, just get an attorney and have them write it. I mean, It'll go faster, smoother. It'll be more efficient. I know it costs, but I think you'll get a better outcome if you go that way.
Yeah, I think sometimes I think it's very difficult for people outside the system to realize just how hard it is. I am with them that the system is too complicated, but we're stuck with it. And I just navigating the labyrinth that is the IRS or a state taxing organization. I mean, it's gotten to the point that a regular person with a regular background, even if they're a smart person, you just can't do it. And even if you can do it, it's going to take you 4 or 5 times as long as somebody who isn't familiar with the system. And that is one of the things that a CPA or a tax attorney provides, is just knowledge of the system. Right. Because sometimes the majority of the battle is just getting the dispute in the hands of the person who actually has the authority to fix it. And sometimes if you go down the wrong hallways a bunch of times, you'll never get it in the hands of the person who even has the ability to fix your problem.
Truer words could not be said. That's everyone. If there's one thing I want everyone from this podcast to take away, was what Josh just said right there. That to me defines more broadly tax controversy, because I don't do a lot of tax controversy. I used to do it a lot. But when a tax controversy matter comes up, I'm always like, you got to get that to someone that knows what the pulse is of the IRS. I have no idea how they're looking at these issues right now. I have no idea who has the authority to solve it. I'm telling you, understanding that is critical.
Yeah. And the only reason that I know it is because I do it every day, right? And so a taxpayer, but taxpayers don't end up with just repeated disputes with the IRS. You wouldn't survive it. Right. And so, usually they have 1 or 2 things come up that they need to fight with the IRS. They've never been in that system before. And so it's unfortunate, but it is so complicated that even a really intelligent person, it doesn't make sense. It's not always logical. And, you end up having to talk to people in 3 different time zones. And it's so complicated that it's an exercise in frustration that people don't need. And I get a lot of clients who've tried it on their own, and they've given up on trying to be able to solve it. And that's how they end up at my desk, is because they've wasted months and hours of their time and feel like they've gotten nowhere. And it's just because they took the wrong path and they didn't know it. So,
Very true. Very true. Okay. Well, Josh, it's been really enlightening today. Loper Bright, PLRs. Thank you so much for sharing your experience and all of that.
No problem. Thank you for having me.
Yeah, I really want you to come back. You don't have to commit to me now, but I want you to come back in January. I want you to give us the 2025 digital asset cryptocurrency kickoff for the year. I want you to give us all the good stuff. I feel like we didn't even tap one of the main things that you do, which is, my understanding is that that's one of the big spaces that you operate in. And I want to do an entire podcast where we just kind of talk about that, the new Form 1099 DA, all the stuff that's going to be kind of floating around that people should expect 25 and 26. So hopefully we'll see you back in early 2025. Thank you again for coming on the podcast today.
No problem. I'll definitely be back. I love digital assets. I got involved a while ago, and it's been part of my practice ever since. So yeah, absolutely.
Awesome.
You've been tuning in to the Essential Tax Podcast with your host, Mishkin Santa. You can find this show on all the major platforms, including YouTube, LinkedIn, Apple Podcast, Spotify, and on our website, thewolfgroup.com. Thank you for your positive reviews, comments, questions, and for sharing this show with others.